Welcome to the Retirement Guide Podcast. I'm your host, George Jameson, the owner of Capital Wealth Group, a fee-only advisory firm. Whether you're nearing retirement or already retired, join me each week as we explore the world of retirement planning and equip you with the knowledge and tools you need for a successful retirement. Welcome back to my podcast. I'm George Jameson, certified financial planner and founder of Capital Wealth Group. Today, we're continuing our conversation on how to create a low-cost living trust online and why homeowners need one. First, we're going to talk about some common mistakes to avoid when using online services to create a living trust. Number one, not using state-specific trust documents. Make sure the platform you choose customizes your documents according to your state's laws. The site I use, Trust and Will, does this by providing attorney-designed documents that comply with your state's legal requirements. And then number two, not properly signing the trust. Your trust must be signed in front of a notary public, and depending on your state, you may need a witness as well. If this step is skipped or done incorrectly, your trust could be invalid. And then number three, not transferring your property into the trust. This is pertinent whether you hire an attorney or you do it online. The biggest mistake people make in general is creating the trust, but failing to transfer ownership of their assets into the trust. You'll need to draft a new deed naming your trust as the owner of your home and record it with your county. You must include the name of the trust, the date it was established, and the trustee's name. This is crucial. If you don't do this, your home and other properties that require deeds will still go through probate. Now, how to transfer your home into your living trust. To transfer your home, which is often your biggest asset without beneficiaries, into a living trust, prepare a quitclaim deed naming your trust as the new owner. Sign the deed in the presence of a notary public and possibly a witness, depending on your state. And then three, record the deed with the county recorder's office, where the property is located. Remember, while this process is relatively straightforward, it's crucial to ensure it's done correctly to maintain the validity of your trust and to avoid probate. Our living trust will hold our home, maybe a rental home nearby, and your personal belongings. In South Carolina, where I live, you may want to put your cars in your living trust as well. However, in other states, you may be able to avoid probate without adding them to your trust. Like I mentioned in the previous episode, all your liquid assets can avoid probate without transferring them into your trust. Again, we're talking about simple living trust here. There may be reasons to put accounts into your trust, but for now, we're keeping it simple. If you need anything more complicated, please hire an attorney. So accounts like 401ks, IRAs, Roth IRAs, all have beneficiaries, and they will avoid probate. Again, for bank accounts, tell your bank you want to add a POD, paid on death, to your account, and then add your beneficiaries, just like you do with your IRAs and 401ks. If you have brokerage accounts, call your custodian if you are a DIY, or ask your advisor to add a TOD to your account. Again, TOD stands for transfer on death. And again, you will add your beneficiaries just like you do with your IRA and 401k. These accounts do not need to go into your living trust because you have beneficiaries set up for these accounts and they will bypass probate. Of course, if your beneficiaries are minor children, you can still list them as beneficiaries on these accounts. And if something were to happen to you and your spouse, if you're married, your designated guardian will manage the accounts and the withdrawals on your minor children's behalf. The minor will only take over the money when they reach the age of majority. You can also have the trust as the beneficiary in this case. But if you do, I highly recommend you hire an attorney because it complicates things. So how to include personal property and valuables into your living trust. This is usually done through an assignment of personal property document, which you'll sign alongside your trust. For valuable items, consider documenting details like appraised values, which can help your heirs avoid tax complications later on. The primary method, like I said, for transferring personal property to a living trust is through an assignment document. This document, often called an assignment of personal property or schedule of personal property, is typically included as part of your trust documents. The first option is called general assignment. In most cases, a general assignment using broad language is sufficient. For example, you might use the phrase like, all my furniture, or all my personal belongings. This approach shows your intent to include these items in the trust without listing each item individually. The next option would be specific listings. For valuable or unique items like artwork, collectibles, expensive watches or jewelry, you will want to be more specific. Creating a detailed inventory of these items can be beneficial for several reasons. It clearly establishes ownership within the trust. It helps preserve the stepped-up tax basis for appreciating assets, and it provides valuable information for insurance, copyright, or authentication purposes. So here's the process. Create an assignment document, which should be included in your trust paperwork. List the personal property you wish to transfer, using either general categories or specific items as appropriate. Now let's talk about trustees. So selecting a trustee and co-trustees. In most cases, you can serve as the initial trustee of your own living trust. This allows you to maintain control of your assets during your lifetime. If you're married, you probably want to choose the co-trustee option. This makes you and your spouse co-trustees of your living trust. So choosing a successor trustee. Selecting a successor trustee is critical for ensuring the trust continues to function properly if you become incapacitated or after your death. The number one option would be a family member or friend. Many people choose a trusted family member or friend as a successor trustee. This person obviously should be responsible, trustworthy, and capable of managing financial matters. You can also choose multiple successors. You can name multiple successor trustees to serve either together as co-trustees or in a specified order. And then the third option would be a professional fiduciary or professional trustee. If you do not have a family member or friend whom you trust, a professional fiduciary like a bank's trust department may be appropriate. But if you do choose a professional trustee, keep in mind they can be quite expensive over time. And if this is what you prefer, I would highly recommend hiring an estate attorney to help you make the right decisions. Remember, you can change your trustee or successor trustee designations as long as you're competent, giving you flexibility as your circumstances change over time. Now let's talk about the distribution of trust assets. After you pass away, or if you have a joint trust, after both you and your spouse pass away, the trust needs to be distributed. Many will have the assets divided up among their heirs as soon as the last spouse passes. So first you have the lump sum distribution. You can specify that beneficiaries receive their entire inheritance at once after your death. This is the simplest method and what I recommend for those setting up their own living trust online. But it may not be suitable for all situations. If this choice is not right for you, you should hire an estate attorney to help you make the right choice, because it gets more complicated when the trust continues on past you and your spouse's lives. Another option is called staggered distributions. You can arrange for beneficiaries to receive their inheritance in portions over time. For example, a percentage at certain ages. You can also opt for annual distributions over a set number of years. Another option would be specific dollar amounts at regular intervals. Another option would be discretionary distributions. You can give the trust discretion to distribute funds based on certain guidelines or criteria you specify. This might include distribution for education, health, maintenance, and support. When setting up these distribution methods, it's important to consider the unique needs and circumstances of your beneficiaries, as well as your overall estate planning goals. If you prefer a more complicated gifting arrangement, then doing a revocable trust online is probably not for you. If you don't want to keep it simple, or you don't have a grown child or good friend you can trust as the successor trustee, and you have substantial assets, by all means, please consult with an experienced estate planning attorney who can help ensure that your trust is structured in the most effective way for your specific situation. An online living trust isn't for everyone. If your situation is more complex or you need specialized advice, definitely consult an estate attorney. But for millions of homeowners in the U.S. with fairly simple estates, for example, you and your spouse own a home, or you own a home, some personal belongings, a couple cars, and investments, setting up an online trust is a straightforward and affordable way to protect your family from the headaches and expenses of probate. Thank you for tuning in today. I hope you found this information helpful. Remember, the goal is to make things easier for your loved ones when you're gone. And a simple living trust online can do just that without breaking the bank. If you have any questions, feel free to reach out. Until next time, take care and have a great day. Thank you for tuning in to this episode of The Retirement Guide. If you enjoyed this episode, please subscribe and leave a 5-star review to help others discover the show. For questions, ideas, or discuss your retirement plan, reach out to me, George Jameson, at Capital Wealth Group. If you'd like a free retirement review, visit our website at capitalwealthplan.com to learn more. Thank you for listening. Stay tuned for more insightful retirement planning in future episodes. And now for the disclaimer. The information discussed in this podcast is for general explanations and education only. It is not tax, legal, or investment advice. Before considering acting on any information heard here, first consult with your tax, legal, or investment advisor. Thank you and have a great day.